Hello, dear students. I welcome you all once again to my class 11 of this series of talks that we are having as part of our quarantine classes, if I may say so. Now, in the last 10 classes that we had in jurisprudence, I have covered the syllabus of module 4 of our course on jurisprudence, which deals with American realism. Now, from today onwards, I'll start the last module in our jurisprudence syllabus, which is natural law and legal rights. As I've told you, that it is because of the fact that I felt that probably you will not get to read about legal rights if you don't study legal rights in jurisprudence, because we do not have jurisprudence in 2 semesters. We only have jurisprudence in 1 semester. So therefore we are not studying legal concepts. But the concept of legal right, I guess, was such that if not studied in jurisprudence, probably a law student, undergraduate law student, would miss out on it, and that's why I had included legal rights in module 5, despite the fact that perhaps there is no logical link between natural law school and legal rights as such. So we'll take up legal rights later once we have finished our discussion about natural law. Now, you all must be wondering that right from my first class till probably my 40th or 45th class today, today I am still talking about natural law, and now I'm saying that we'll start our module on natural law, and this is quite intriguing because probably in every class that I have taken so far, I have referred to natural law, and which is why in my initial classes I told you a little bit about natural law. And therein I told you that according to natural law, law is the product of reason. And reason is something which is in the realm of a priori reasoning. And that a priori reasoning is the source of natural law, which we also referred to as in our conversation when we were studying is law. We call natural law ought law, but ought here refers to the indispensable character or indispensable notion of what the law ought to be, and that is why the term ought law. That means a law which is contrary to this ought is not law, and that's why the term ought, which invariably also I have referred to in several of my classes by referring to the realm of ought. Even in my last module's discussion on American realism, I have on several occasions referred to the term ought. Even so, while talking about realism, I said that in most of the cases the interpretation of is comes from the realm of ought. So what is it that we are saying? If you bring in the natural law analogy, we are actually saying that in most of the cases, the interpretation of is dependent on natural law. By natural law, we mean interpretation which is actually coming from reason. And that is the reason why I told you that according to natural law, law is the product of reason. Now, but since we are studying natural law as a module now, so we'll try and study as to what the natural law is about, how it originated, and how it is understood presently. Now, if you study natural law, you would find that you are actually studying history of natural law, and one important thread that runs through the entire chapter on natural law is the fact that you do not find one coherent concept of what the natural law actually endorses, and except for the fact that this common understanding of every conceptual argument pertaining to natural law being the product of reason you will not find anything common. In fact, you may actually find things which are contrary to each other, but both being grounded on reason. So one may say that natural law means religious law, whereas the other may say natural law means what is rational. And many a times you will find that religious laws and rational, what one may think as rational, appear to be contrary to each other, and both may actually be claiming that theirs is an understanding based on their reason. So that is the problem with natural law, that it does not tell you one coherent idea or one coherent concept of what the law is, except for this underlying feature of any argument pertaining to natural law being actually based on this understanding that law is, after all, the product of reason. Now, what is important in natural law? Natural law is testimony of the human's quest for search for absolute values, and also probably of its failures, and which is why you would always find this one common thread running around the entire discussion about natural law as to how human beings always want that the resort to something higher, that their claim to invoke something higher must not be snatched from them, and that any system which is man-made must always consider itself to be subservient to something higher, something above it, so that the authority of human institutions must always be amenable to challenge on the ground of it being not consistent with those higher ideas, with those higher principles. So that remains one constant idea underlying natural law, that because of the fact that we are actually in a quest for search for absolute values, but we do realize that these absolute values perhaps don't exist in a manner wherein we can have complete unanimity in respect to anything common. But one thing which is common in relation to invoking of natural law is that we want to always ensure that the resort to something higher, or human beings' capacity or ability to resort to something higher or invoke something higher so as to challenge the authority of human institutions, must always exist. And so that any man-made institution must not assume that just because of the fact that it has assumed power, whereby even the lawmaking authority has been achieved, has been given to that human institution, that institution must not assume that lawmaking authority makes that human institution not amenable to the clutches of law. And that's why this very apt quote which says that be you howsoever high, law is always above you, very well captures the essence of what the resort to natural law actually means for we the human beings. So as I said, that resort to reason has actually given rise to versions of natural law which are in fact contrary to each other, and that's another hallmark of natural law theories. So law is the product of reason can actually give rise to something which is authoritarian, because a person who is authoritarian may and actually enjoying the authority over people may actually say that because of the fact that I possess this stature, my reason is equivalent to whatever the universal reason is, and therefore whatever that I say is the product of that universal reason, and therefore whatever that I say is natural law, non-derogable. And that's why that can very well pave the way for an authoritarian regime to actually rule by its whims and fancies. As opposed to this, there can be an approach of individualism, wherein one may emphasize upon individual liberties being originating from law being the product of reason, and insistence on individual freedom as something which is the byproduct of universal reason. Both are contrary to each other, because an authoritarian regime may actually want to muzzle individual freedom. At the same time, individual freedom may would insist upon extricating individuals from the clutches of any authoritarian or despotic rule, and both invoking the same reason. Likewise, natural law theory can be progressive, can be conservative. Progressive, again invoking the same reason; conservative, again invoking the same reason. And that's again another distinctive feature, that two very contrary contents of natural law can actually invoke the same reason, which we say is the source of law in natural law. Likewise, natural law can be religious and rationalistic. The example that I gave in my discussion on the last slide also. Religious and rationalist. Both, again, basing their argument on reason, but may actually turn out to be contrary to each other. Likewise, that an argument based on natural law can be absolute, whereas an argument based on natural law, both invoking reason, can actually be relative. Now, this is very important to understand, because that's how probably we understand natural law in contemporary times. But we'll come to it later. What do you mean by absolute? Absolute means that there cannot be versions, multiple versions of what is the product of reason in relation to a particular issue. So therefore, content emanating from natural law while addressing a particular issue cannot be more than one. There has to be only one right answer. So in that sense, absolute. So if you say death penalty is wrong, so if you take it to be an absolute argument, then you are saying that it will admit no exception whatsoever may be the social and historical context for it. And therefore, the fact it is a universal wrong. Likewise, where the notion wherein you are saying that no, it's relative. You do agree that law is the product of reason, but you need to take into account the specificity of time and place. And that specificity of time and place is something which will have its impact, and therefore it will resist any universal prescription for addressing any issue. And that merely because of the fact that you are resorting to reason, and because that reason has to be universal, it does not necessarily admit one universal answer compulsorily. And that's interesting. That makes it very, very intriguing that you can actually invoke natural law to come up with contrary ideas and contrary conceptions. And that is why it is so complex and difficult to comprehend, and also because of this is the reason why when we are studying positivism, I told you positivism is a reaction against natural law, because according to positivist, reliance on natural law makes the content of law ambiguous. And why ambiguous? Because the same natural law can actually be invoked to come up with contrary content of law addressing a particular issue. So therefore there is no finality, and therefore positivism comes up with this argument that right or wrong, there has to be finality, and that is more important, and whatever is the form of that finality, that should be taken as law until unless it is changed in future by way of amendments. So that's one very important characteristic of natural law. But what is also important to see again is, like I said in my last slide's discussion, that be it authoritarian, individualistic, progressive or conservative, religious or rational, absolute or relative. What is again constant is the human being's appeal to resort to something higher, whereby you are actually challenging human institutions' authority to be the final arbiter in deciding as to what is right and wrong in relation to a particular issue. You can only challenge the authority of that institution by invoking something higher. Now, it is up to you what you invoke in the form of something higher, and that's why we have variance. What is important is that one is always resorting to something higher. Now, in legal parlance, what do we mean by resorting to something higher? What is this? What is the juridical or juristic sense of resorting to something higher for a law student? Now, in this context, you would find that when we say resort to something higher, for in juridical sense, we mean these two things. That is, first, that natural law as an ideal, or which invalidates an inconsistent positive law. So if a positive law is inconsistent with the content of natural law, then that positive law is invalid. Secondly, natural law is an ideal to which positive law ought to conform without its legal validity being affected. So here again, natural law is an ideal, but what is important is that it is expected positive law ought to conform. So there is optimum insistence on positive laws complying with natural law ideals. But what is also important is that non-compliance with natural law ideal does not result in invalidating the positive law. And if you see what is there in brackets, the first one refers to ancient or medieval law theories, whereas the second one is the contemporary or modern understanding of legal systems. Second one very distinctly also tells us the arrival of the modern day state, because positive law originates from states' authority, and therefore states not willing to accept the authority of natural law to such an extent that inconsistency of positive law with natural law would result in invalidation of positive law. Whereas an ancient and medieval law theory is insisting upon natural law to be such a higher law that inconsistency of positive law will result in positive law getting invalidated. However, it is also interesting to know that constitutions worldwide have this concept of resort to something higher, and wherein constitutions ordain positive law to conform to the constitutional ideals. But at the same time, you will also find that several of the constitutions of the world do not have a provision wherein if positive law is not conforming to natural law ideal, the positive law gets invalidated. So, whereas if you look at the example from Indian Constitution, you will find a provision like Article 13, which says that a law which is inconsistent with the provisions of Part 3 to the extent of inconsistency is void. So herein we have an example of natural law as an ideal. Natural law as an ideal contained in the form of fundamental rights in Part 3 of the Constitution, which is mandating that a positive law which is inconsistent with the provisions of Part 3 to the extent of inconsistency is void. So herein, though we are saying that the second one is the modern theory, but if you were to look at the Indian Constitution, or for that matter US Constitution, you would actually find that we are actually following this ancient or medieval law theory. But that does not mean this is a medieval idea in that derogatory sense in which we use the word medieval. So that's one important thing to understand, that though we are saying that this categorization tells us that contemporary notion of natural law is not the one which can actually invalidate positive law, that is because that is only saying that this is the contemporary understanding of how the states would want the positive laws to be evaluated. But that does not mean that constitutions worldwide necessarily follow the second model. Like you are seeing the Indian example. we are also a modern legal system, but at the same time, our constitution mandates that if the positive law is inconsistent with some of the constitutional mandates, it results in invalidation of positive law. And we are also aware of basic structure theory under the Indian Constitution, wherein even a constitutional amendment as positive law can be invalidated by the courts in India if the courts find that the constitutional amendment is actually violating the basic structure of the Indian Constitution. So again, the resort to something higher is resulting in invalidation of positive law, and even that positive law, which is not an ordinary law but a constitutional amendment. So therefore, that's very important. And why am I saying that even this is an example of natural law? Because definitely basic structure is also resort to something higher, using our reason, to which we want the positive law in the form of constitutional amendment law to necessarily be consistent with. And that's one important understanding coming from this juristic sense of resort to something higher. Next, natural law is credited with two lasting contributions which it has made. One is the quest for a universal order governing all men. So you have very importantly the concept of international law, wherein the world community has actually entered into this dialogue of having a universal order, at least a minimum universal order which is necessary to be complied with all the civilized states of the world today. So therefore, this quest for a universal order is very, very important. Even in relation to human rights, we insist that there are certain universal human rights, and therefore that kind of universal respect for those human rights are kind of universal order which admits no derogation. And that's one very important contribution, again coming from natural law. Secondly, the concept of inalienable rights of individuals. This again is a very, very profound contribution of natural law, that from natural law comes the idea of natural rights, and these natural rights being inalienable. So therefore positive law cannot take away these inalienable rights of individuals, and this again is lasting contribution of natural law. The reason why in my last slide's discussion I was talking about fundamental rights as coming from that as an example of that higher natural law. So that again is one very, very important contribution of natural law in the form of inalienable natural rights of individuals, which admits no derogation, meaning thereby that positive law cannot be inconsistent with this inalienable rights of individuals. However, you should also take into account when you are talking about inalienable rights of individuals that probably in several countries you have the model of resort to something higher for positive law, but not resulting in invalidation of positive law. So in that sense, obviously we are not talking about natural inalienable rights of individuals in such a manner that inconsistency of positive law with these natural inalienable rights will result in invalidation of that positive law. Nevertheless, what is important is this realization of this concept of inalienable rights of individuals. And this again is a very, very significant contribution of natural law. And another very important thing is that because of the increasing talk and discussion about human rights especially, we have this notion in fact growing, wherein inconsistency of positive law with the inalienable natural rights is seen as resulting in invalidation of positive law. And therefore even a country like United Kingdom, which till 1998 had no such provision wherein its laws could be challenged on the ground that it violates natural law, has enacted a law called Human Rights Act of 1998, whereby even UK laws could be challenged in UK courts on the ground that UK laws are inconsistent with the provisions of European Convention of Human Rights, of which United Kingdom is a party. And that's very interesting. That you have a country which has so far rejected this argument of inconsistency with inalienable rights resulting in invalidation of positive law, has actually come up with a law very recently in 1998 allowing its court to actually do this judicial review of legislation. However, it's also important to note that under the Human Rights Act 1998, the decisions of the courts, UK courts, on such judicial review of legislation questions are not binding. So that still tells you that probably the argument that inconsistency of positive law with inalienable natural rights does not result in invalidation of positive law is still there if we talk about United Kingdom. But what is important to note is that at least even a country like United Kingdom, which has no such provision till 1998, is actually allowing its court to do a judicial review of legislation, given the fact that those judgments will not be binding. It is nevertheless very interesting to also note that the same UK law can even be challenged in European Court of Human Rights, which can declare UK law to be violative of ECHR provisions. And under the ECHR, European Convention of Human Rights, the decisions of the European Court of Human Rights on such questions are binding on United Kingdom. So therefore, there appears to be a conflict between United Kingdom's commitment as a member state of ECHR and the domestic laws which are there in UK in the form of Human Rights Act 1998. So that's a separate study to be undertaken for scholars interested in that area, but nevertheless an important piece of information for various students of natural law in particular. So that is it for today. I hope I could instill some curiosity in you in relation to our study of natural law, which we'll be undertaking in our coming classes as well. Hope to see you soon. Thank you very much.